to order. Merry Christmas to everyone coming up. I don't know that we'll have any meetings between now and Christmas, so hope everyone does have a Merry Christmas and families are all safe and travel coming in. And thankful for the holiday season. Conflict of interest. As the Surry County Board of Elections, we have a duty to avoid conflict or appearances of conflicts of interest. Does any board member have a known conflict of interest or any appearance of a conflict with respect to any matters coming before our board today? If so, please identify the conflict or the appearance of the conflict and refrain from any participation in this particular matter. We have our minutes from our November the 3rd meeting. It is read before you. If you will take the opportunity to look at those and see if there is any corrections, additions, or deletions. And I do have one. It is not an error in the minutes. There is an error of one thing that I said that caused it to be reflected in the minutes, and that was pertaining to the program where the Swain County Board of Elections Director was interviewed. And so was our state elections director, Karen Brinson Bell. And I told everyone that it was going to be 7 p.m. on that Saturday night on North Carolina Public Broadcasting System. It was by Tim Boyle on Spectrum News.
Okay, because I looked too. I looked.
Yeah. If you look on Saturday night at 7 p.m. at PBS, I'm sorry, you missed it.
Masterpiece Theater.
So that is a correction as far as one thing that I spoke wrong about in the meeting. But the minutes are correct. The minutes are correct. Oh, okay. Yeah.
Look at it, it's on what's on. Yeah.
Mr. Chairman, make a motion on the minutes to approve as presented. Second that motion. We have a motion. We have a second. Is there any discussion for the motion? If not, all those in favor of the minutes of the meeting for November the 3rd to be approved, say aye. Aye. Opposed? Signature to be approved.
I beg you to, that mouse is behind you. Would you mind just moving it to where it says got it so that'll go away? You have to see it. Thank you.
And other duties as assigned. Okay.
In this big boardroom we have, there's so much room to walk around.
Is anybody else up there?
No, no one's on. It doesn't look like to me.
As the minutes are going around the table for signatures, I will open the public forum portion of our meeting. Is there anyone present or online that wishes to speak to the Surry County Board of Elections? Well, I just didn't know. If I hear no one else wanting to, I will close the public forum portion of our meeting. Next on the agenda is 2024 early voting appointment. Madam Director.
Thank you. If you will look at your packet, you should have a document that reads resolution on appointment of early voting officials. And the state board did discuss this at their most recent meeting, November 28th. And this gives us a little more guidance more than we had at the last meeting about how this appointment process for early voting precinct officials will work. And this is the main reason we needed to meet today, because it does read that before each primary or election, each county board shall set a date when the county board will hold a duly noticed public meeting to appoint early voting officials to sites other than the county board office. So I did get clarification from Paul Cox that appointments do not have to be made for the home office site, the county board of elections site. So appointments that we will need to get from the party chairs will be for the one Mount Airy site. And with that being said, number 2 states that at least 21 days prior to the appointment date, the county board shall send an email or letter via U.S. mail to the chair of each political party organized in the county, notifying the chair of, number 1, the county's board appointment date, and number 2, the party's deadline to provide recommendations for qualified early voting officials, which shall be the 5th business day before the appointment date. So with the holidays and everything between now and early January, and our training dates are already set for early voting, we really need to require the parties to have names to us, if at all possible, by January the 2nd. So then we have time for the board then to meet 5 days later, approve those appointments if the board deems that's what you want to do. Then we have time to turn around and call these people if they are people that we don't already have on a list.
Which is possible.
Which is very possible. And in order for them to meet the January 25th deadline for early voting training that's already set on the calendar. January 25th is the nighttime training for early voting, and January 26th is the daytime class for the training for the officials. So it's one or the other, whichever fits their schedule. It's the same training, but we always offer that one at night and one in the daytime. That's just a recommendation. You know, the board can vary from those dates a little bit, but we do need a little time to contact new folks who are not familiar with the early voting process and make sure, of course, they can commit to 15 days and be available and bear the responsibilities that go along with that. And then get everything ready before they come to training, because also they have to have their background check, drug test, all paperwork, because they are payroll folks. And that's it's going to take some time, a few days as well, for HR to be able to complete that process.
If they're not already in the system.
If they're not already in the system.
Now, if I can interrupt or ask, this is for the early voting sites, not to be confused with what we did in early November, I think it was.
For election day precinct.
For election day
Correct.
precinct. Okay, so this is step 2.
I think the state board, it explains here in the resolution also that the state board is leaving it up to the counties. So everyone's going to pick their own day that works with their schedule, that works with their HR, that works with their training. So that's why the state did not select a date. Like election day, it's set, a set date, not every county, has to have those people appointed by that time. So that's why, again, I felt like we needed to get this taken care of before the holidays are upon us. And I think that the parties, the good thing for us, everyone talked to their party, and it made contacts, and the work has already been ongoing, so I don't think it'll take them by surprise. So hopefully this January 2nd deadline, I don't think they would have an issue meeting that, even though there's a lot of holidays within that time frame.
And people that have been approved for the precinct day workers, can they also serve as early voting?
Absolutely, and thank goodness they do.
So,
Because we have very, very few, I can only think of a couple right now that are early voting that are not election day that we currently have.
so they still would have to go through the process of being submitted for early voting by the party chair.
Yes, even if they're already on the election day approval list.
Just a total
Total
separate.
separate list of appointments. Mhm.
So what do we have as a possible date for our duly noticed public meeting to appoint?
I think first we need to decide on what day we're going to ask both party chairs to be able to submit. And we would have 5 days after that to do the appointments. So again, the 2nd of January, 5 business days after that would be the 9th of January.
I'm open. What says the board?
That makes them the best tale.
Do you all in agreement on that, January 2nd would be doable for the party chairs?
It's the Tuesday after New Year's Day,
Yeah,
right? Okay.
yeah.
First working day.
First working day,
Okay.
yeah.
So the party chair will need to work through Christmas to assemble it.
Yeah, but again, I think it was good that you all made some contacts there with the party chairs to maybe go ahead and get that ball rolling.
Which theoretically, they could submit the same list if they submitted for
They definitely can pull from that election day list, yeah.
that. I mean, that makes it easy.
Yeah,
So in addition to the names already submitted, they have the option of adding to that list for the early voting, correct?
yes, and let me add one item I did leave off. Not only though will this be chief judges and judges, this will be chief judges, and assistants, because now they are referred to as chief judges and judges instead of each county called them something different.
So we have some uniformity now.
Yes.
Okay, that's good.
I'm assuming, though, they will still be hourly paid. That's what we pay. I've not heard any discussion that
Yeah,
makes me think otherwise.
I didn't see anything that changes that part of it.
Okay, that's what I was assuming, because we do pay them at an hourly rate versus a election day rate.
Mr. Comer is signaling that he is good for January 9th.
Okay.
Is everyone else's calendar open for that day?
Yes.
Do we need council with us on that day?
I've got it open right now, and so if you need me, I'll be here.
Okay.
Probably by the end we'll need you for something
I-
else.
I-
I have a big one.
I suspect there'll be another
After January
update
1st.
with lawsuits
Yeah.
that would be worth it.
That's very likely.
I'm not a betting man, but if I were going to be,
Yeah.
I would say yes, that's true.
If there's no objections, we're all in agreement, we would like to select January the 9th. I don't think we have to have that as a motion. We selected that date unanimously, 2 p.m. 2 p.m. Is that good?
That's good for me.
barring no snow or ice.
And, the county board can separate dates for the appointments, and we also, this allows for staff to be able to fill in if there's sickness, if there's appointments, if there's things that appointed officials have come up during that 15-day period. The resolution by the state board and the law does allow for us to fill in with non-appointed people in order to have a full staff at the early voting site. So,
And no doubt you are already thinking in the Mount Airy early voting site that with Mount Airy elections and we're getting some contested positions that you would have sufficient enough number of people to handle that, plus the photo identification, et cetera. Okay.
curbside
And your
and
adoption
everything,
also.
yeah.
Great.
The only thing, Mr. Chairman, I will need a motion on is, the date that you wish to require the party chairs to submit the, recommendations of appointments.
We had mentioned January the 2nd. Do you think that that is adequate, that they be informed by mail prior and have to submit that?
Yes.
Absolutely.
Would there be a motion?
of time already.
I'd like to make a motion, Mr. Chairman, that we vote on agreeing on the 2nd of January, 2024 as the date that we require the party chairs to submit names for early voting.
We have a motion. Do we have a second? Any further discussion from the board?
I think it's adequate time. I mean, it's the 8th of December. I know we've got the holiday, but it's the 8th of December. It's almost a month. And that's, as Michelle said, has been working on this, so.
Good deal. Okay, we'll vote on the motion to have January the 2nd as a submission date.
Barbara, I'm sorry, I didn't hear the second. I'm sorry.
For the submission date for the county party chairs to have the names of the early voting site, particular Mount Airy. All those in favor, please say aye.
Aye.
Opposed? We have a unanimous vote for January the 2nd.
Thank you. We will get the party chairs notified. And I will just add one thing before Mark, gets into his portion, but the state board did just send this out right before the meeting, so I've sent you all an email with this, but this is the new requirements to same-day registration, so I'll send this to you as well, Mark, but, they are really stressing in the email how, critical it is for us to get poll workers trained on these new requirements for same-day registration. So we will need to focus a chunk of time for sure during trainings on this for early voting.
I noticed in the election line today under the North Carolina, they only had one post and it was pertaining to a lot of significant untrained people in the municipal elections held in 34 counties, I think.
Yeah. As a trial run for photo ID.
Where they were in the article, the news article, going in and talking to some of the folks that their vote was not able to count, and some of it was because of valid reasons, and some of it is because of lack of training.
Yeah.
It's a little bit of a pitfall that doesn't need to be.
basis of the article was more training is needed.
Good.
Their examples were in Guilford, so that's
Oh,
the article, yeah.
Yeah, and you're gonna shoot that too.
Yeah, well, she said,
Charlie got sort of.
Charlie
Eviscerated.
referred to the board.
Yes. And no doubt it's in most of our more highly populated counties and cities. This is definitely going to be a challenge. Not one that I'm not convinced we can overcome here, but certainly a bigger challenge in some of the bigger cities. But training with all these new laws is really going to be important.
Okay, is that it for the early voting?
Yes, sir. It's all from me there.
We'll move on to the law. Council Fleming?
Last time I was here, I said that I would come back if there's any update on the various lawsuits that have been filed concerning Senate Bill 747 and 749. I wasn't at your last meeting because, to my surprise, there wasn't any real news on that front. And I only have one thing to report, and I think Michelle has already stolen my thunder on that and sent out the notice to you guys that in the governor versus general assembly lawsuit, the 3-judge panel did issue an injunction, and I've looked at the order. It's after the boilerplate beginning. It's like 2 lines, and it basically says that the section on the state board of elections appointments, the section on local government boards of election appointments, and also the section on severability, which is really sort of boilerplate. That those 3 sections are stayed and are going to stay as it is now until there's a further order from the court. So you guys are not going to dissolve at the end of this year, as I was telling you last time, unless it was changed with an injunction.
No clock
And
yet,
it's,
Drew.
yeah, and it is,
No clock yet.
We were in clock.
Clock. Last time you said, where's my clock? Do I get a clock?
Oh,
So
I take that back, all them good words I said. They were premature.
I appreciate them for as long as they last.
But they are in the minutes, so.
That's all.
so that's, and it's my understanding from the attorneys for the governor's office that they are going to request a hearing date sometime in February for a summary judgment motion, which will have a lot more finality than this current injunction. This current injunction says everything stays as it is until the next order. And I don't think anything's going to happen in that case until February. So this board is going to stay here at least till sometime in February, and then we'll see what happens. Now
Surely they would not, no matter what the outcome of that is, surely they would go through canvas of the primary. Oh, that would be.
I feel confident that both sides will say, okay, it's February now. Even if you're going to rule, for the governor, then it stays like this. If you're going to rule for the General Assembly, let's pick a date when it'll be in place.
Yeah.
Somewhere down the road. That's more
March.
manageable. I would be surprised if either side wants any change in February. I feel pretty confident that both sides would not want a change until some more manageable time down the road. But that's not decided yet.
Who will be hearing this? Is it the same 3?
The same 3-judge panel will hear the motion for summary judgment, at which point they can make what is at that level the final decision. Then it goes up to the Supreme Court. I think this is and frankly, I should know this, there are some things that are designated to go straight to the Supreme Court and don't go through the Court of Appeals. I think this is that sort of case, that it goes from the 3-judge panel straight to the Supreme Court. But it gets appealed. It'll be available for appeal after that motion for summary judgment.
See how it wouldn't, whoever it votes, it'll be appealed. right?
Oh, yeah, yes. It'll be appealed either way. The question will be, if the ruling continues to be, and the 3-judge panel, one thing that is of interest is they have to make a finding that it appears more likely than not that the people asking for the injunction will prevail. Now that's a little bit of a forecast. It's not quite as much of a forecast as it sounds like, because any panel or judge can say, well, now that we've learned other things, we thought it was going to go that way, but we're going to check, but we changed our mind based on this other new evidence or new argument. So it is a little bit of a forecast that this 3-judge panel, that it definitely shows you that they think that there's some validity to the argument. And if they continue to think that and uphold the and rule for the governors on the motion for summary judgment, then obviously the other side will appeal. The flip side of that, if they change their mind and rule for the General Assembly, I am confident that the governor will appeal. So then you have a question: what happens? Do they continue to stay? Again, if they rule for the governor, they'll certainly continue to stay because they think that's the way it ought to be permanently. If they rule for the General Assembly, they could say, but we're going to keep everything as it is till after the appeal, or they can set a time when it reverts back to the way the statute's written, or they can flip it at that point. The third thing I don't think is going to happen. I don't think anybody wants this to have to completely change everything in February. And this assumes that it gets heard in February. It could be that it's heard later than that. So there's still a whole lot of questions about it. If you were to, again, I'm not a betting man either. I've dealt with too many judges to do that. But if I were to bet, I would think that you guys will be the board at least until after this election, and then I would not guess what your status is going to be. A little bit to my surprise, all these other lawsuits that I mentioned last time I was here, I have not seen any injunctions. I have not seen any action in those cases. That doesn't mean that something might not happen Monday. But the one thing that has happened is there's been one more lawsuit added to the mix, and this was a case in federal court. It's Williams versus basically General Assembly and the State Board of Elections, and it is a redistricting challenge. It's a gerrymandering challenge, and it's based upon race, but not politics, not political stance. Which is, you remember the big lawsuit that was several years ago was political gerrymandering, which was somewhat unusual. This is a racial gerrymandering challenge, and it specifically cites districts, North Carolina's House districts 1, 6, 12, and 15. I want to say, I'm not sure about that last one. It definitely includes 6 because that's the one I live in, and I noticed that. I think who's y'all's House representative? in Surry.
Sort of
Sarah
thing.
Stevens.
Okay, yeah. No, not General Assembly, federal.
You're talking about Virginia Fox?
Yes, yes, okay. And that's not one, that's what, 4 or 5?
Fifth.
Five, okay, yeah. So fifth isn't specifically named in that, but anytime you have a redistricting challenge, the demand is to redraw all the districts, because you can't draw one without really redrawing them all. It just got filed Monday. And I haven't studied it yet. And it was in federal court. So that's one more I will put in the list to look at and see how things go in the future. The only other thing that I wanted to update you guys on is I thought that the last state board meeting, there were a couple things that are worthy of discussion here. One, you've already heard about the resolution was adopted about the appointments. One other resolution, not a particularly significant, but I thought it was a little bit, it's worth mentioning, and I think Michelle is going to send that resolution out to you guys, and that is the new statute requires that if the State Board of Election is going to let the executive director issue directives to local governments, the state board has to, by resolution, authorize that. Up until this point, it's basically been inferred from the statute that says that the executive director can issue memorandum on behalf of the state board, and the statute that creates local boards requires you guys to follow directives from the state board and executive director. But now it says there's got to be a resolution from the state board to do that, and they did that at the last board meeting, and so I think Michelle is going to shoot that out to you guys just so you got it and put it in your file. And so any directives that come out from now are under the aegis of that resolution. The other thing that was pretty interesting, well, it was all pretty interesting to me. And I know you guys don't want interesting, you want straightforward and easy. And I think ultimately what you guys rolled is, in my opinion, ultimately easy, but sort of a complicated way to get there. And this was about, there was a challenge issued challenging the voter registration list and saying that the voter registration list contained names that were acquired in contradiction to HAVA standards. You guys know what HAVA is, and today I'll say HAVA or HAVA. I'm not sure there's
Data.
Yeah. But and you'll hear me say both, because I've never figured out which is the right way to say that abbreviation. And the other, and I will start with a caveat and apology. I always try to be brief, and I'm very rarely successful because all these things are complicated, and I think you guys got to hear all of the ways that if I come to a decision, you got to hear how I got there. And unfortunately, I also think this stuff is interesting, so I kind of jump into it. So this is going to be a slightly complicated way to get to what in the end I think is a fairly straightforward answer, at least for you guys. And so the board was presented with this challenge of the voter registration and saying that it was in violation of HAVA requirements. And I guess this is to the state board staff's credit. Their their response was, yes, that's right. We've done it wrong. And this is how we propose to fix it. And we think that's the right fix for the state board to adopt. It's not the fix that was requested in the challenge. And this all has to do with voter registration, how voter registrations are created. Right now there's and the challenge, and this was sometimes lost in the discussion, I thought, only has to do with voter registration to register by mail. So this doesn't count DMV, and it doesn't count walk-ins. And that's a discussion that I think that got lost in because the section that's cited is in the HAVA section 303, and that section is called computerized statewide voter registration list requirements and requirements for voters who register by mail. Which is sort of and frankly, that's sort of an awkward, you would think voter registration make the same rules for everybody, but the statute doesn't exactly do that here. And the complaint said a couple things. One, that the training is incorrect, the application is incorrect, and because of that, you should purge the list of everybody who did not put their driver's license and or social security name in the mail registration, which statewide apparently is some 200,000 names.
And that number came from the petitioner.
It was thrown out there just as sort of offhanded in the discussion from the board, but it did sound to me like it came from the petitioner, not. Yeah. And to get at this, you got to look at how voter registrations by mail happen right now. And there's an application, and there's a North Carolina statute 16382-4 that talks about the contents of the application, and it has a list of 11 things. And the statute, now I'm just talking about the North Carolina statute right now, says that local boards are required to request these 11 bits of information: name, date of birth, residence, county of residence, date of application, gender, race, ethnicity, political party, telephone number, and number 11 is the one of interest, driver's license number, or if the applicant does not have a driver's license number, the last 4 of their social security number.
And Mark, if I may, that closely mirrors what HAVA has to say as well.
Yes, but not quite, and and frankly, that's where the state messed up, and where they've acknowledged they messed up, because the statute says you've got to ask for these things, but it doesn't say they have to reply or the registration is void or anything like that, and it doesn't say you've got to inform the applicant that of their obligation. It says you just got to ask. And some of these things, gender, race, ethnicity, if somebody doesn't put it, nobody says anything about it. So and clearly one of the problems was the application does not say what HAVA requires, and that is you have to inform the applicant that you've got to give us a driver's license or social security number, unless you just don't have it. You can't just say, I've got one, but I don't want to give it to you. And that's where, and so the application, I think, was based they looked at the statute and created the application from that point. And the training was followed the application and followed the statute, said you gotta ask, but it doesn't say anything more than that. And
Can I have a question?
Yeah.
When you say it states that you have to ask, are you saying asking is
Is-
giving them the document?
yeah,
Or when they
I
turn
have
the
to ask
document,
on the form. Yeah,
Okay,
if
that's
you
what
put
I
it on the form, that's,
we're asking
that's-
by
that's-
it
yeah,
being
you've done what
presented to
you-
them
yeah.
on the form?
Okay.
That's what I wanna know.
The form has to be revised, it's presently in use.
yeah, oh, absolutely,
yeah,
yeah, to,
But my question on a county level, have we met our responsibility is asking, once they turn it in and saying, oh, you left this off, or is asking, presenting the voter registration form to the applicant?
I would argue, and that hasn't been put directly in front of anybody. And the complainant on this might have a different opinion than mine, but I would argue that, that if you look at the statute says, it says information requested of the applicant. And so if there's a slot for that on the application, then you fulfill the statute.
You've requested it.
Yeah, and that is your directive from the state, until they fix it.
You fulfilled your obligation.
Yeah, but they have now, as of the last meeting, acknowledged that application is not the way it's supposed to be. And it's my understanding that they are drafting a new application they're gonna send out to everybody.
In January. We've not heard when in January, it just says in January.
Yeah, hopefully the sooner the better.
So the old form does not adhere with the law, and the new form is supposed to adhere to the law.
Yes.
To be able, I'm jumping in real quick, to be able to also implement this, it's not only just the application, but the computerization of the registrations
And
probably will require more columns, that they want to have to put these things in that is presently not there, or
It would have to be a Seams enhancement.
so
Who
that's
knows
a
when that
total.
yeah, that
That's not gonna be anytime soon, so.
the training will be different.
Money.
Yeah. And it's gonna be different because, if you look at HAVA puts the requirements together differently. Again, those requirements are only on registrations by mail, but it's gonna be one form for everybody.
Yeah, same form.
Yeah, and it's section, part 2, section 303.
You all have that in your.
And the 303 talks about, and these are requirements for, and this is another thing that's important that I'm worried that this is going to get lost in translation as the state talks to various local boards, which is one reason why I think it's good to have this discussion. And that is, my opinion is that HAVA is plain in that it makes these requirements on the state to get the mechanism right for how to do this. It does not, HAVA does not require local governments to do more than they have the resources to do. And I'll get to what I think that means down the road. But this is an obligation on the state to maintain a statewide voter registration database. And this is how it's supposed, and then it's got a lot of requirements about how they're supposed to go about doing it. You turn a couple pages there from, where section 303 starts, and you get to subsection 5, and that says verification of voter registration, requiring provision of certain information by the applicants. And right there it says that except as provided in clause 2, and I'll get to that. And notwithstanding any other provision of law, and that includes 16382.4, an application for voter registration may not be processed by the state unless the application includes driver's license or social security number. Section 2 is that for those folks that don't have those, then that requirement is not there, and the state has to give them a special ID number.
Who wouldn't have those
Who wouldn't have a social security number?
besides, Amish is the only ones I know that, I mean, am I missing?
Who doesn't have a social security number is a very small list, and I wouldn't trust my
What that
knowledge
list
on exact, on telling you
includes, okay.
exactly who that list is. The number of folks that don't have driver's licenses is
Right, that's
is
a
not
more-
a small list.
right.
It's not a big list, but it's not,
significant.
it's not, it's
It
not
is.
It's
immaterial.
not insignificant.
Yeah.
Right,
But who doesn't have a social security number?
Yeah.
It's not a citizen.
And Mark, may I, just a
Sure.
clarification,
You know?
a person who wants to register to vote doesn't have to provide their whole social security numbers, just the last
Last
four
four, yes,
digits.
that's correct. Last one.
Yeah.
So that reads a lot more mandatory than what the state requirement is and what the current form follows. So the change that's going to be made to the voter registration form now is going to require a certification from the applicant in which they swear that they will provide a driver's license or social security number, or they do not have it. And they can't just say, I don't want to. No, if you've got one, you've got to do it. Now, if they don't sign the certification, you don't have a complete application. But if they do sign it and they don't, and they certify that they don't have it, the way I read HAVA and what the state has done is that the local obligation is to send that to the state and say, here it is, this is a completed form, they certified this. And the verification is the obligation of the state to do. And part of the reason I say that, one is the way HAVA is put together is this is a state maintained voter registration. And so therefore they're the ones that have to maintain it. And I think that's clearly the state's interpretation.
Probably the state law, right?
Federal law, yes. And I think, the one thing about elections law is you got to pay attention to the federal requirements and the state. I think what the state did, and I'm not making excuses for anybody, I think what the state did is they just looked at the state statute and created a form based on that. But what the federal law does is it very explicitly says in section 305, and I'm going to read the entire section. It's entitled Method of Implementation Left to the Discretion of State. And then the entire section says the specific choices on the method of complying with the requirements of this title shall be left to the discretion of the state. So this is how I understand the state has decided to address this issue. Start by saying, again, I guess props to them for admitting that they made a mistake, because we all do. But they did make a mistake, and they are going to change the application. Thank you. I talk too much.
I like the
Should this
detail,
be
Mark.
filed in federal court, or is she taking issue the way the state is It's
The,
simply
the,
the federal
the
law.
complaint was, I think, properly placed before the State Board of Elections, because it's saying you guys aren't maintaining the voter registration list the way you're required to under HALA. So I think that was exactly right.
HAVA is a very, very large
63
requirement.
pages.
Where
Yeah.
they tell the Social Security and Social Security Administration, you, SSA, will comply with what we're telling and saying that the chief elections officer of each state sends that 4 last numbers of their
Right.
social with the name for the Social Security
That's correct.
Administration
And,
to check off and verify.
and they send similar requirements, or they make similar requirements of the various states B&Bs,
Yes.
or whatever their state equivalent of B&B is. And yeah, it's 63 pages, and and even by general statute standards, it's not the most artfully written. And they really, it's subsection A, subsection 2. It's
Wow.
you have to really go back 7 pages every time to figure out, okay, this has to do with, for example, this looks like it's across the board for voter registration. It's only voter registration by mail, and why it's limited that way, frankly, I don't know. So this is what the state has done. The state has said, yep, messed up. We're going to change the registration. We're going to make it plain on the registration that there is an obligation on the part of the applicant to certify, and certification is a sworn statement. I mean, lying on certification can have very, very significant impact. And the certification that, yes, here's my driver's license number, or I am certifying I don't have either of those. So that, if people take that seriously, you're not going to get very many that don't have that slot filled in. And the training is going to be make sure that people understand that. If they call up and have a question, yes, we got to do that. But the verification is the obligation of the state. The one thing, there's 2 points to this. One is, I don't read HAVA or anything the state BOE is doing that's going to require you guys, by you guys, I mean you guys and all those folks over there, to do something that I don't think that you got the resources to. Because if somebody mails in an application and they certify that they don't have the driver's license, and for driver's license they leave it blank, local governments, especially the smaller ones, and you guys are on the larger end of the small ones, but you're a small
Still
one,
considered small.
do not have the resources to call up SSA, to call up DMV, and DMV does not have the legal obligation to tell you anything. And I think that's pretty significant. I think DMV would just hang up on you if you called and said, I need to confirm if this guy has a driver's license or not.
But they do have the obligation to give
To
it
the
to
state,
the state board of elections.
because HAVA is very explicit with that, with SS. So, and this, now how the state is going to do their verifications is not plain to me from their ruling. And so as time goes on, we'll get more detailed. But the state clearly feels that the increased obligation for ID at the voting place is going to clear up these issues. Maybe not as quickly as some folks would like, but it is the fail-safe that's going to make sure that nobody votes who isn't who they say they are. And the state's opinion, I think is correct, is that the intent of this whole statute is to make sure that people that vote are who they say they are. So what happens now is the state voter registration, if somebody has not provided the driver's license, and that list should be, whether it's 200,000 or some other number, should become significantly smaller after this with a better application and a better process. When somebody comes to vote, it's flagged on their voter registration. Don't have this information. We need
ID
we
required.
need an ID requirement that's have a certified.
Right.
And there are two kinds of requirements. There's have a, there's to say, oh, I now have a driver's license. Here it is, right? And I think your training is going to change to say when people do that, change the voter registration and put that in there.
You don't have them there in front of you.
Yeah, when you're presented with it, and they want to, in effect, modify their application, you let them modify their application.
Do the update.
Yes. And so, or they're either going to say, oh, I now have one, here it is, and then we'll get repaired that way, or they'll provide this fairly burdensome other HAVA approved identification process, and they vote. So through the voting process, changes in time, and the periodic purges of the voter registration that happen when people don't vote or don't get their correction, I think the state's opinion is that's how we're going to, in the long run, correct the statewide voter registration database. And somebody could argue that the state maybe ought to be more proactive in doing that. They ought to randomly or call check on every single one or randomly do it. I don't know if the state's going to do that or not, but frankly, that's their job. And I'm not being facetious. Happily, it's not ours. I mean, there are things that we should do absolutely everything we're told to do, and nothing that we're not told to do.
Right.
And so that's when I said it ultimately comes down to a fairly simple answer for this board. My read of the law, and I don't have the vote, and you guys do what you need to do. But my read of this law is that with the corrected registration form and the corrected training that's going to go along with that registration form, I believe that everybody will be in compliance with HAVA, and that and I guess maybe saying more than I should, frankly, I think the way the state wants to handle correcting the voter registration down the road is probably HAVA compliant, especially since they got such broad discretion. But even if they're not, that's somebody else's issue, not ours. You guys' job is to implement the new application and the training that goes along with it. So in the end, for you guys, I think it's a fairly simple situation.
Mark, if I may ask you a question. In reading the state statute, it appears, and as I had said to you last week, I'm not an attorney, and I don't pretend to be an attorney, but I've had a lot of exposure to contract law, and that's been very helpful in understanding what this is saying. Is it fair to say that the state statute is broader in the sense that it's just not by mail? It is with any voter registration, in-person voter registration, and by mail.
Yeah, yes and no.
Okay.
which is the kind of answers why people don't like people like me, to me, the correct answer is yes, it's broader in that it says on the application form for voter registration, you shall ask all these things.
Yes, shall request.
Shall.
So you've
request.
got to request them.
Yes, exactly.
The no part is the statute doesn't mandate the sort of things that we're talking about with the certification, putting the onus on the applicant and making sure the applicant knows that they have to give the driver's license, because they don't have to give gender, race, and these other things.
Right.
But you gotta ask.
Right.
So yes, this is broader in that you've gotta ask this of everybody. No, it's not broader in that it doesn't mandate what the HAVA mandates as far as the only justification for an applicant not to put the driver's license or last four of the social is if they just don't have it.
Right. If I may again, where HAVA and the state statute seem to mirror is that we as a body, elections department and board and staff, we should be asking every potential voter that wants to vote for either their driver's license and or their last four digits of the Social Security. And again, in both cases,
I think that's accurate. Yeah.
and in both cases, if they attest that I've not been issued a driver's license or a Social Security number, which is the latter we agree is going to be rare, then they've got to, we assign them an ID number. They still have to show voter ID in North Carolina
When they vote.
when they vote.
Yeah, that voting requirement is not affected by this at all.
Right.
Yeah.
But we still have to request it.
Yes.
And if they don't, then the state also has the fact that they've got to attest to the fact they've never been issued.
Yeah. Yeah. On an ongoing basis, yeah, I think you're exactly accurate there. On an ongoing basis, the application and therefore any explanation of what's on the application has to be plain that you, applicant, have to give the number 11 on this requested information.
Right.
You have to give that unless you don't have it.
Right.
And you don't have the option of saying, I just don't want to.
Right.
And you've got to certify that to that fact. At that point, I think the better by far the better read of both statutes is then we've done our job.
Right.
And we send it to Raleigh and they do their job.
Right.
But is that person then registered to vote?
If they sign the certification, that they, 99 times out of 100, at least, people are going to go, oh, okay, 9654.
Yeah, last four digits.
And or the driver's license and move on. For those folks that don't fill that in, if they don't sign the certification, then they have not completed an application, in my opinion.
Yeah.
Now, I'll be interested to see what
If they
the
don't sign the voter registration application.
certification.
The certification that they have not been issued a driver's license
Right.
and have never been issued a Social Security number. If they attest to that and put themselves at risk legally, then if they sign that, as I read this, we have to accept their application as a registered voter.
Yeah, and we all know that you're not supposed to make assumptions, but I am assuming, based upon what the board said and did, as the state board said and did at their last meeting, that the application is going to look something like the current registration form with all of these notes, probably an asterisk or a note in bold after number 11 that explains what HAVA says. And then instead of just a signature for the applicant, it's going to be a signature and a certification saying, I certify that all of these things are stuff.
It'll be noted then that
You're fine.
I don't
it'll
think
be
you'll,
noted that is required.
yeah.
Required.
Yeah, right. Now, things will get complicated if the applicant lets you sign it and not sign the certification. Then, then, then I think that there'll be grounds for further beef with the state. But if they sign it, but don't sign the certification, you got to ask this the Board of Elections, DOE, do we send this to you or not? And we'll have to follow that instruction.
So are you saying if they check here and sign here? Because there is no signature portion.
Yeah, it's going to change.
Oh, you're saying for the next one?
Yeah,
I thought,
Oh, no,
there
no,
is
no,
no,
where is
that?
I'm talking about.
The change
Yeah,
form.
right, yeah.
Okay.
Yeah, and
Okay.
between now and then, I think you just got to keep doing what you're doing. I don't like that you have an interim that's distressingly long from the last board meeting when they found that there was a problem and it's going to be January before you get the new form. But I don't think we've got an alternative.
That's the question,
Yes,
right?
we-
Not check if you do not have
Just,
a
the state
driver's
board
license.
has been wrong since 2003.
Yes.
But,
Yeah.
right,
Yeah.
no, but now, they cannot.
Mr.
check
Chairman,
that.
that's
They must
exactly
blank and sign.
my concern too, is that
not do nothing,
you know, for any, if this is new to anyone, in my homework, HAVA was enacted in 2002. I could not find when the state statute 16382-82.4 was enacted, but nonetheless, I'm going to say it's been many years. And so the state
It was enacted in some form or fashion in 1901.
okay.
But it's gone
Few
through.
years apart.
Yes, it's gone through, just
So-
glancing at it, it's gone through like 20 revisions.
Right.
Yeah.
So the net effect is that the state has not been in compliance with the law, and based on their guidance or lack thereof to all 99 of the local election boards, as a result, we haven't been in compliance with the law as far as asking for this information. Now, not going to harp on the past,
Right.
but if this is the law, it has been the law, do we have the legal requirement to begin asking when people come in, regardless of the form? Do we have the legal obligation to be asking voters that come in or that want to register, and during early voting that come in to vote and we see there's no driver's license noted and there's no 4-digit social security, do we have the legal obligation to ask and request it?
I think that's a pretty good question. No, not pretty good. It's a good question. I don't want to modify it. It's a good question. And this is something that pops up in local government in all different other kinds of contexts. I would argue is not the right word. I would opine that local government boards of governments have not been in violation since 2002, even if the state has, because the statute and case law gives us a safe harbor. We do what we've been told. We can't not do what we've been told. So I think we're all fine. But I do think the state,
Well, now that they've admitted it,
yeah.
how much does that change what we're supposed to do starting today? Or as a
Again, I think my personal opinion is the state is being a little bit more casual with this than it should be.
I would agree.
Because I think if it were me, I would have said as soon as it's practically able to, we'll get that application out because we don't want to be in violation anymore. I think for the same reason we were in a safe harbor before the board said, oops, we're in the safe harbor after the board says, oops, until they correct it. So, again, I think they're a little bit casual about it. I agree with them, frankly, that going back and trying to correct it is not a practical approach, and to correct it as things move forward is the better approach and isn't a HAVA violation.
And as I remember listening to the board meeting last Tuesday afternoon for 2.5+ hours.
Those guys are as chatty as I am.
That the complaint that was filed was asking for the state to go back
And
you know, make it whole by going back and having a lot of work. And when I heard that, the complaint, I thought, it's a great place to want to shoot for, but it's just not practical for most local boards of elections to do that with the staffs that they have. So at least we could do that as people come in from this point forward.
Okay, and that's the second part of your question.
Yes.
I think that I would not say, unless the state directive says, I am telling you, you have to inform everybody, that leaves that blank of what HAVA says. I don't think staff is required to inform everybody that leaves that blank that, hey, HAVA says this. But there's absolutely nothing wrong with doing that. Okay. And I think that's part of the training. 11 blank. I don't want to give that answer. Oh, well, this is what the statute says. I think that's the proper thing to do. But again, I don't think that's mandated unless the state specifically mandates it.
And if we, as a living and breathing body in Surry County, if we want to reach the highest point of excellence in serving the citizens of Surry County, then we could choose to request the information.
What I would recommend, and again, I like my role over here, and I like you guys doing what you guys do over there. But my recommendation would be nothing more formal than instructing staff to include in their training to inform applicants where practicable of statutory requirements. Yes, it is. Because there are going to be instances where it's just not possible. And I don't want it to look like staff has somehow violated a directive from the board because they just didn't get the opportunity to say everything. Or if somebody might misunderstand what they're told and all of a sudden you have to deal with well, did they comply or did they not? So my recommendation, and again, this is just a recommendation, is that there be consensus from the board, if there is consensus from the board, to instruct staff to inform people of this legal obligation, of their legal obligation, where practicable.
When did you say that you anticipate the new forms to come?
As I understand,
In January.
Yeah, as much detail as we've gotten is, we'll get you the new forms in January.
Mm-hmm.
The state is going to be putting on a parade that is going to be the lead car will be the application, and then coming up behind is going to be training, and then the state is going to have their mechanism to record this in the scene. That's their next float coming down, and then their methods of verification of this will be at the end of the parade. It's a lot. This is not going to happen overnight. The application needs to be as soon as possible.
Yeah.
The state's going to have to figure out what are we going to do with this new information with a revision to SEAM. Because
and SEAM is I think everybody understands that the SEAM correction is going to be way down the road.
Because of dollars.
Yeah.
I suspect that they recognize that full compliance, as it should have been all the time, but recognizing that the issue is there now and having to come into full compliance is going to require a great deal of work, and there's much to be done on their end, and I suspect That's why it may have appeared more casual. I'm not sure if that was the word you used, but that may be the way it didn't, it's not come across as their hair is on fire when actually probably when the camera turned off, I suspect that their hair is on fire.
That is actually an excellent point because, because I've made those exact same statements and say, yes, we're fine, we're
We
moving
were
on
working on
that.
that.
And as soon as and then go, guys, circle the wagon, yeah.
And Clark, to that point, in listening to the NCSBD board meeting on Tuesday, the complaint was filed in October. So the state was wise in stating that we were already working on this before the complaint was filed. We'll take it on face value. Yeah. So.
And, okay, this is really in the category of me talking too much, but I've been dealing in with governments my entire career, and I've spent all that time trying to decide am I an optimist or a pessimist, and to my surprise, I'm a lot more of an optimist than I thought I would end up with. I think for the most part, almost everybody I've dealt with, and it's the almost that gets you in trouble, are very conscientious about this. I suspect that they probably did recognize it, if not before, at least as soon as it happened, and are working on it. And I think they're going to be conscientious in finding a solution that works. And that's my assumption is that the new form will check all those boxes, to say the cliche.
I tend to agree, and I suspect we'll see it quick.
On that note, I have an update. Paul Cox did say today that they expect to have information to each county, hopefully by Monday.
Oh,
There you go.
That's not going to be a new voter registration form.
No.
But they're going to have guidance on how to handle current voter registrations. And there will be manual edits you have to do in Teams. It will not flag anything. So that means staff is going to have to watch and manually enter the information. If the information is not there, then they will have to manually send a letter to the voter saying your application is incomplete. Seems the way it's set up now, if it's an item that's already in there, it flags it automatically, then it produces a form letter. So I assume that the guidance on Monday will have that information as well, what that letter needs to state to be compliant with the resolution and the law.
Yeah, interacting, yeah. That's encouraging.
Good.
Yeah,
Yes,
yeah,
good.
yeah.
Good.
Yeah.
And he did not say numbered memo. He never used that terminology. He just said guidance.
And
They're working on it.
yeah,
They're working
Either
on
way,
it.
we're getting closer to resolution.
Yeah.
It sounds like it. And I think to Jimmy's point, hopefully then we won't be breaking the law,
Right.
to use your language.
We're adhering to the law.
Adhering to the law, yes, sorry, adhering to the law. And I think that's what we all need to hear.
Right.
yeah, that's all very encouraging. I'm glad to hear that they're giving at least some interim guidance. Now, frankly, they, according to the resolution they passed in the same meeting, I think that resolution specifically says that we're authorizing the executive director to send out guidance in the form of numbered memos. So hopefully it'll be a numbered memo because that's just a little cleaner. But you still have the statutory obligation to follow what the directives are, whether they're numbered or not. Yeah, it's nobody else is gonna say this to you, so I will let you periodically. You guys got a hard job, and it's a complicated job, and nobody's gonna appreciate it. And it's a lot more complicated than everybody thinks it is.
Without a doubt.
Just got a little more complicated.
And that'll keep on happening. And I'll plan on being here January 9th and with any news. Now, judges don't like to do stuff over the holidays any more than anybody else. So there may be no news for me to give you on the lawsuit front.
And whatever, if we do receive something Monday, of course, I will copy you on what I send to the board.
Want to hit replay because you've run through 2 Diet Cokes. And you have done wonderful with what you have brought to the board, and I commend you. Let's go back and replay just about to the front where we were talking about the lawsuit that the 3-judge panel put a stay or hold on the change after January 1st. That lawsuit is larger than just the state and county boards of elections as far as the makeup.
Well, there are 2 lawsuits. There's one lawsuit that we're talking about here, which is based on, is it 749?
49 is the makeup of the board.
49 is the makeup of the board. That changes the way the state board is done from the 5 board to a 4 board, and all the local boards from a 5 board to a 2 board. That injunction says all of those provisions that have all of those deadlines and all of the changes to the board, they are frozen. They do not apply, and they're on hold until there's further orders from the judge. So you guys carry on exactly as you are right now. There's another lawsuit about virtually all the other appointments, changes in the appointments where the General Assembly changed appointing authority from the governor to the General Assembly. And there's a lawsuit in all of those. And that lawsuit has also, a stay has been issued in freezing all of those appointments and upholding the appointments that the governor made sort of after the lawsuit, before the hearing, except for the EMC, Emergency Environmental Management Commission. For some reason, they excluded that and said, no, that doesn't, we're not freezing that. And there are also too, like, I think the building code appointment council, they said we're not going to talk about that because that appointment starts until 2025 anyway. And so we'll have an order before then.
So in February, whenever the 3-judge panel revisits this, if they issue a summary judgment, that summary judgment can still be appealed to the Supreme Court.
Right.
Okay.
And almost certainly will.
I just wanted that clarification.
Yeah.
Thank you.
Yeah, there's the reader's digest for it.
You see, the 3-member court were 2 Republicans and 1 Democrat, and
That's
all
correct.
3 voted for the stay.
Yeah.
Do you see that? It's going to the states. The makeup of the state Supreme Court is more Republican now than before.
It's now 5-2.
But there are 2 Republicans voted to stay at this time. You think that's any sign of what may happen in the courts?
It has, I would say, marginal.
No.
I would treat it as marginally encouraging, but really, what the Supreme Court does is the Supreme Court is not going to be influenced by the fact that 2 Republicans at this stage felt the way they feel. Now, what I time around for this topic. And so there are three cases that say that the General Assembly changing the appointment process in ways that look a whole lot like the current one is a violation of the separation of powers. So, so it'll be interesting to see how the Supreme Court does it, because several of those Supreme Court members, both Republicans and Democrats, are very much strict constructionists.
Mhm.
And if you're a strict constructionist and this is what the president says, we're not going to be activists and change things, they're less inclined to change things. Now there's some that are fairly new, and I don't know what their inclination is. And I, again, it's a good thing I'm not a betting man, but that's something I would not bet on how those guys are going to go. So, and that may be a wiser opinion than mine. I just don't know.
I mean, it's been tried before, but before it was more evenly split, I think, the state Supreme Court. So the General Assembly says, we got a better outlook on the Supreme Court. We'll try it again.
If I were a Republican member of the General Assembly, I would think that this is the best time to give this a swing.
All of the rest of this.
And I'm glad I'm not a member of the General Assembly, Republican or Democrat. It's not a job that I would want if you handed it to me.
Thank you, Mark. Thank you.
Yes.
That's a
And
whole lot.
and I wish it was less complicated, but I don't think
It's
it's
law.
Yeah.
I'm glad to hear.
Me too.
Amen. Amen.
Okay,
Now, we've done it before without you.
other business before the board?
I just have one thing for the board to be thinking about. We have some time on this, but the second absentee meeting for the 2024 primary election period is February the 6th. That is also the last day of the conference. So they have decided to end the conference at 11 instead of 1. So they are instructing the boards to consider opening the meeting at 5 virtually and going into recess until 8, 9, whatever the next morning. Or pushing your 5 o'clock meeting back to 7 o'clock in case you feel rushed to get back and whatever we have to do to get the ballots ready for the board. So just be thinking on, and I tell you what's going to happen is nobody's going to show up at Tuesday sessions. So it's unfortunate for those speakers. I personally think they should condense the conference into one day. They can do it. Pack it all into one day and just let us have Tuesdays. Again. Yeah.
Well, it's a reasonable.
You're welcome to come. I only know one.
It's a reasonable
Oh,
road trip.
I've got that.
If we had one day.
Yeah, yeah. So, but right now they've already committed to the hotel and the venue. So just
Same place.
keep that on. Yeah, keep that on your radar for the next meeting. We will need to decide that so we can make that a public. We will have to notice that we are changing the time if that's what the board so chooses. So.
But we will need to just come back and 7 p.m. or whatever.
Is it a mandatory meeting? I
If
mean,
we have no ballots, if we have 0 ballots,
but we probably will.
but the second one, we probably will. If it was the first one, may not, but if it's the second, and even if you have 1 ballot, you need to convene.
Well, unless it's a small number.
We're not supposed
Okay.
to.
So the next state training will be the 5th and 6th of February.
5th and 6th of February.
In Concord.
in Concord.
So it's such an
Yippee,
exciting
yippee.
location.
Get to the racetrack.
And let me tell you, we, as a whole, complaints were just about 100% from the counties,
Yeah,
Sound
good.
like
As far as the
municipal.
room facilities.
Just,
everything, yeah.
just for future discussions with whoever set those up, the North Carolina County Attorney Association had a standard, it was beach, mountains, beach, mountains.
They say
And
that
that's
there's
where
nowhere that
everybody's-
can hold us. That
Oh.
we're so limited as to, because if you do all 5 board members and 2 to 3 staff members, you times that by 100, you're looking at 1,000, 800 plus people with state board staff. And, but I'm like,
No place in Wilmington for that.
That's what they say.
Or
Asheville
Asheville.
and Asheville both have pretty large
I know.
convention centers.
They do.
And so does Wilmington. Wilmington's got a gigantic convention center.
Yes.
You know, you may not be able to get on Wrightsville Beach or Atlantic Beach, but you can do Wilmington.
Very much so.
And frankly,
Everybody was saying,
Bar Center and Cary, of course, that's
Well, they
not
usually-
as big, but
They usually
Raleigh.
flip them from around Cary to Concord. Just Cary's time.
Yeah.
they need a conference committee desperately.
That place in Wilmington is gigantic.
It is.
It is.
It's a nice facility.
Yeah.
It's right on the river.
Yeah, you can,
It's sad.
Easy to the historic district.
To
Yes.
the conferences I have been to, it's sad, and I'm not talking the state board, but it's not.
and it would surprise
They
me
make better use of
if
their
the one
time,
in
too.
Asheville and the one at App are too small
Mhm,
to get that many funds.
mhm.
Are there any changes to this from what you had sent us the most recent?
Yes.
Oh,
Hey, Clark, here we go again, but the changes are, as of today, the state board released dates for the general election. That's reflected on there.
okay.
So that's the update. And then, of course, it reflects the state board's decision to, which I think I've already emailed the board on, that absentee, by mail, or now it's just absentee ballots.
Right.
Will be dispersed beginning January 19th
Nothing
instead
through,
of January 12th.
nothing through the primary has changed though.
Nothing through the primary has changed. Unless you
I
had
had
it
put everything from the last one you
from the
had
most
sent
recent, before this one.
in my
Okay,
telephone. I just
then
wanted
you're good.
2021.
Now,
Oh,
the one thing you don't know yet is because it is, the one thing that's in these new laws that haven't been, that was not stayed is that, the state board of elections is supposed to give you the names of people in the presidential primary in their December 19th meeting.
I'm sorry, say that again. The first part. I heard the December 19th. I'm sorry, what?
Yeah, the presidential candidates,
Oh,
that list, they're supposed to give you
at the state board's December?
they're supposed to vote on that and disseminate it, in their December 19th meeting.
Okay, and that's the same meeting of any non-unanimous early voting plans, I think, which we will not be a part of this time. Woo-hoo-hoo. That's good. Okay, well, that's here, that's
Yeah.
a little over a week away.
December 19th.
And now, could they meet on the 19th and then recess to another time? Probably, I'm not sure that complies with the spirit of the statute, but I suspect you're gonna do exactly what they're supposed to do.
That's when they say who's gonna be on each party.
Yeah.
And then on down the road, we will need to look at, what was referred to as a supplemental absentee meeting is no longer on your schedule reflecting as such, because that deadline is 5 o'clock for anyone who voted a provisional ballot to come and provide proof of ID or whatever it is they might be lacking.
On the Thursday before Canada.
Thursday before canvas, so that deadline is 5, our meeting starts at 5. So if someone comes in right before the deadline, we do need to have time to get that information before the board can meet. So further on down the line, we will need to look at, do we want to push that back to 6 instead of 5? Do we want to push the meeting to 8 in the morning, right before canvas? I'm not pushing for that because we are scrambling that morning.
That
So
morning's
if
tough.
that morning's tough.
I'd rather see us push it back to 6 p.m.
Yeah.
And if that's adequate time for what you need to do.
I do think with photo ID being in the mix for provisionals, I do see people coming in and providing that between election day and that 5 o'clock deadline. Maybe
Yeah,
not.
Do we need to push it to 7 p.m.?
No, I think we probably could, but there should just be a few right at the deadline. So just so we can get those in. No, I think 6 would probably definitely serve us well.
Do we need to have a motion on that time change, or do we just need to agree to
So
change the
we
calendar?
would have to have a motion, but we can do that at the next meeting as well.
That's for the after before the canvas of the primary.
The Thursday evening, yes. Mhm.
Okay. Next meeting,
Something to think on for the next meeting.
you say depends on when our next meeting is.
No, I said something for the next
For the
meeting,
next
so that would be January 9th meeting.
January 9th, at what time?
2. Yeah.
Oh,
Oh,
Never been such a time in the history of the world.
This year has went very, very, very good. And then that's all I have.
That's all you got.
Mm-hmm.
Okay. All right. Well, hope things are going good with all of the candidate filing and no glitches or such. No problems.
Some interesting things, but no glitches. Very interesting things, but no glitches.
Very,
And I'd say next week's just gonna get more so. Really. It's
but it'll work
been
out.
slow. It's just been an unusual, it's just been a little unusual, yeah, in comparison.
They'll line up next week. Friday at noon.
Friday at noon. And then we were talking, that people will be confused. It automatically assumes 5 o'clock.
Right.
And that always makes us, we will bear that
Hey, how
complaint.
you doing?
Yeah, well, sorry.
One of the very first election matters I had to deal with was when a remote, I don't know why Johnson County did it this way, but they had a remote site that was taking candidates as well as the main site.
Yeah.
And they thought the staff thought it was 5 instead of noon. And they had candidates that filed after afternoon, but when the staff thought they could still take them.
So how did that play out? How did that?
They had to reject the candidacy.
Oh.
I think it's been noon a long time.
Had they advertised it that they could?
Probably, if they thought it was 5.
No, it was, I don't know how it happened, but it was not advertised that way. The advertisement was, you got till noon, the statute was till noon. The sign at the main office said till noon.
But staff permitted people to come in after that.
Personnel.
It
But I do not feel sorry for those people
yeah,
now.
it was a situation
Right, the reading
Some
your own
disappointed
information.
Oh, my goodness.
Absolutely.
And it's been known for all the way back, Dwayne.
Huh?
Oh, yeah.
The news has been,
Forever,
yeah,
forever, as long as I,
yeah.
Now,
Our
this
director,
is when I was in Johnson County, so it was at least, and it was early on, so it was probably 20 years ago.
our director was, successful in the last Board of County Commissioners meeting, and she was there and, met before the commissioners for approval for the monies for a lot of the change out for, improvements to security and such. And tickled to death to hear that. And some of those changes, I think, are under construction as we talk.
$25,000 moved from the general fund approval, and it was a unanimous vote.
That's
thank
correct.
you to the board and thank you, Madam Director.
With some discussion, but, it happened. Yeah, and things
Congratulations.
are already underway.
Yeah, that's really good, because circling back around, the Board of Commissioners doesn't understand how complicated your job is or your job. And so that's a real victory, that we can get them to agree to something like
And
that.
speaking on that, they don't know the complications and what all is coming is before us, even ahead of us this year. I think that's one of our next steps, is to get started with making sure that we have the adequate personnel to handle all of the new responsibilities that's been placed upon us.
And Mr. Carter took, it was a successful lunch yesterday.
Sorry that I missed it.
He did get to speak with the county manager, and, he said just that, and with a little more, he pressed it a little bit more with him.
I'm sure, Mr. Knopf was, all ears.
He was.
Good.
Appreciated his listening, and thank you, county manager. And he was interested in a lot of the stuff that was taking place here, that the commissioners had approved monies for.
That's great.
I appreciate his interest. The staff that was with him.
So we are, it looks like everything's on track to meet the January 1st deadline for all those improvements.
Great.
All of them.
Fantastic.
Great.
And I know also tax and cooperative extension are going to benefit from a lot of this too. And they have both thanked this department for getting that ball rolling for them as well. In the way of panic buttons, the back hallway is going to help with them, and the bollards out front as well is going to help with them. So they were happy about that too.
No, that's really good. And security is distressingly a way bigger issue than it's ever been. That's-
Yeah.
Anything further from this board for today's meeting?
Mr. Chairman, may I introduce a subject?
Please,
This is, not so much that we should make a decision today. I would like to ask, all of my esteemed colleagues here on the board, and our Madam Chair and our attorney, who, thank you for explaining, AVA and state statute 163-82.4. In thinking on this for 2 weeks now, we as a group and an entity have an opportunity, I think, and I welcome any input. We have an opportunity to demonstrate to our citizens of Surry County, and for that matter, to all other 98 election boards across the state, that we in Surry County take the election laws that are on the books and have been on the books for years very seriously, and that we are committed to adhering to federal HAVA and state statute pertaining to voter registration. And so that we answer any questions that our citizens may have regarding this, going forward, because a lot of this is going to be total news to a lot of our citizens, even though we've talked about it. And so say we have an opportunity, which I think is a wonderful opportunity to show our citizens that our elections department and our board are putting them first and making sure that we are adhering to both federal law and state law, and as well as guidance from the state. But should there be anything left off from the state where the law continues to hold us accountable, I would like to ask all of us to consider a resolution, voting on a resolution that just merely states our commitment to our citizens of the county, that we're going to adhere to the law always, and that our staff is committed to applying the laws, and that involves the questions that we are mandated to ask going forward. So say, not asking for something today unless there's openness to discuss it, but would like to make a final decision as you think about it in the January meeting at the latest. And again, just to confirm, I think it's an opportunity for us, if nothing else, to let everybody know that cares or questions anything to do with the elections. And there are plenty of people in this county that are questioning, understandably, for various reasons. And, you know, anytime when the state says, we haven't really been complying with the law, that just throws fuel on the fire again for anybody that questions whether or not we're adhering to the laws of the land. And I think that's the main purpose of my suggestion, is that we consider a resolution, vote on that resolution, whatever the outcome is, but it shows that we are taking an extra step in our leadership roles to our citizens and to the various parties and to just our Lord and Savior, that we're going to do the right thing always do the right thing by the law.
Would the board like for council to look into authoring a such resolution to be looked at and possibly?
I'd be happy to do something. You shoot me
Quick as I.
sort of the portion of the minutes that you're talking about, and I'll try to get it out to everybody well before any meeting you consider, with the proviso and consideration that I'm not advocating for or against any resolution,
Right.
but if you were to consider a resolution, this is the way I'd draft it, sort of thing.
Okay, great.
One thing that I've considered discussion with the board at this point is that, yes, the state has erred in not moving the ball forward on the field from 2002. So, but I don't feel like that we need to do anything before the state hands down their mandate in starting with that parade of responsibility that they are going to have to pull off with the application being revamped. I don't think that we need to do anything until that comes along, because information that we'd like to obtain, it might be obtained in an application that the state board or the council on the state board looks and says, no, it's missing a little something of it. This is no board. We're going to need to let them take their leadership that they need, that they have the responsibility to do.
And the way I understand what you're saying is basically this board saying you're going to do what you've already frankly, by means of your oath and by your practice over my entire experience with you guys, always do, and that is be very conscientious about following the law. Now, unfortunately, a lot of people outside of this room think the laws reads differently than it actually does. And I don't think in the one place where they miss the boat the most is that you're you're not a legislative body. You can't change policy. You have to implement policy. You're an administrative board, and part of doing your legal obligation is doing what the feds and the state tell you to do. But it's, to me, it'll be a fairly, I'll be very careful about how I put it together, but I don't hear the request as anything other than you affirming what you've already by oath said you're going to do, and what I see you guys do every day.
Well, that's what my assumption. I've been here 5 years and I thought I've been following the law the whole time.
And Drew,
You have to.
to the very point, and so do our citizens. They think we have, and then there are others that don't think we have. I mean, to be quite frank.
So I can appreciate that.
The words continuing and ongoing will be in my resolution.
As I say, it's an opportunity for us to show leadership to the citizens, and hopefully we set a model that the other 98 local election boards may want to borrow from our own leadership. And I don't see any downside to it whatsoever.
We're not counting Allegheny County.
That's all you leave
Oh, yeah.
You're leaving
We'll keep Allegheny in it, but
99.
but as I say, there are already citizens in this county that think this body is not adherent to the law because they don't understand. And
Right.
Mr. Payne has explained it clearly what our legal obligation is. We know it, but anybody on the outside, I dare say, out of 100, there might be one that would say, "Oh yeah, I fully understand what the role is of our board." So again, with all of this conjecture going back and forth with the federal law and the state law, I do see it as an opportunity to make a statement of commitment and reassure our citizens that we are doing the job that they expect us to do.
I personally will be happy to sign on to a resolution that is general and affirming that we're doing what we've done. I would be very hesitant on anything that draws any specifics to this or any other pending matter that is in.
No, I agree with that, because to me, that would look like we're trying to cover something. And I do not see that at all.
I'm gonna run from that.
Yes, and if I may, it's no different in principle than when we agreed that before every board meeting, we were gonna read our conflict of interest statement. It was not something that the board had done traditionally in the past. We decided to do it to remind our citizens that we are committed to high standards.
To remind ourselves.
And ourselves too.
Yeah.
I'm really and truly,
Yeah.
I think that's the direction for that.
Serves both purposes,
Yeah.
Clark, you're right. Not only a reminder to ourselves, but also remind our citizens that we take this seriously.
And that we have been taking it seriously in the
And-
past,
yes.
and we continue.
Yes.
I feel, honest to goodness, Jimmy, I'm happy to, on this general statement resolution, I'm happy to sign on to that. I fear that those who don't think that we do will place a great deal of stock in it.
If we win one over,
I'll be
Clark,
happy.
it'll be worth it.
Listen, I'll be happy. I agree.
It's the first meeting that you and Barbara were, the chalk into. We voted and we passed on the motion and of the code of ethics, which is, you started talking as far as what you would like to have in this resolution. And so much of that is what we agreed to unanimously in our code of ethics as far as how we act and what we're going to follow. So we stood before ourselves and approved this, so to speak. Maybe what Mark might be having is a reaffirming.
Continuing and ongoing,
Going
we're
to
being,
the affirmation
yeah.
from that code of ethics, as far as so much of it.
And we're gonna get,
baptized.
we're gonna get rebaptized.
There you go.
Yeah.
We're going from sprinkled to immersed.
The whole body, the whole body.
Thank you for listening. I have to say,
Thank you.
I just think it's an opportunity for us to show that we're up.
I'm happy to do that every meeting.
Yeah.
Can't hurt anything.
Hopefully, the state board will have something between now and the 9th,
Yes.
surely,
Yes.
that we can use as well.
I suspect that they had somebody working, severals working there over Thanksgiving and we'll have through Christmas.
We've already been told that they're working.
Like I said, I bet when the cameras went off, you could have seen the fire burning.
Well, I will say it was very interesting to read the press release the next day.
How minimal.
How minimal it
That
was
person
compared to
was.
what was discussed during the board meeting.
Listen, I imagine everyone in this room has been in meetings where, when the lights went out, what that worked out.
And all the board meetings that I've had to sit on, yes,
It went from this,
it's happened many
it
times.
went from this to,
Yes, and a few choice words that would not want to be
Yeah,
repeated probably, so,
Okay,
yes.
if there is nothing further,
I'll be happy to make a motion to
for
adjourn.
this, I think we have a motion, I think we have a second, and our vote will be all in favor?
Merry Christmas, everyone.